Chapter 13 Labor Law. Learning Objectives. Enumerate the classification of employees, their benefits, privileges, and policies affecting them. Identify some best practices in handling human resources in tourism establishments. Identify the procedures in handling sexual harassment in the workplace. Explain the rights of workers employed in tourism establishments. Topic outline. Introduction. Constitutional provisions on labor. Classification of employees. Benefits, privileges, policies affecting employees. Laws against discrimination. Best labor practices in tourism establishments. This chapter deals with important provisions governing labor laws as well as the benefits, privileges, and policies affecting the employees. Constitutional provisions on labor. The law, Section 3. The state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concreted activities, included the right to strike in accordance with law. They shall be entitled to security of tenure, human conditions of works, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by the law. The state shall promote the principle of shared responsibility between worker and employers, and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production and the right of enterprises to reasonable returns of investment and to expansion and growth. The law, Section 14. The state shall protect working women by providing safe and healthful working conditions, taking into account their material functions and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. Section 15. The state shall respect the role of independent people's organization to enable the people to pursue and protect, within the democratic framework, their legitimate and collective interests and aspiration through peaceful and lawful means. Section 16. The right of the people and their organizations to effectively and reasonably participate at all levels of social, political, and economic decision-making shall not be abridged. The state shall by law facilitate the establishment of educate consultation mechanism. Classifications of employees. Employees of a company may be classified as follows. Regular employees. These are workers engaged in activities essential to the employer's business, or casual employees who have rendered at least 1 year of service. They enjoy security of tenure and cannot be dismissed without just cause. Casual employees. Their employment is temporary and incidental to the employer's business. After 1 year of service, they become regular employees in the specific activity they are all employed in. Seasonal employees. Their work is tied to a specific season. Regular seasonal employees enjoy security of tenure and cannot be dismissed without just cause. Project employees. They are hired for a specific project or undertaking with a predetermined completion or termination date. The employer must specify the project's duration and scope at the time of engagement. Probationary employees. They undergo a trial period during which the employer assesses their qualification for permanent employment. Probationary employment cannot exceed 6 months, and the employer must specify the standards for regular employment at the start. Employees for a fixed term. These are covered by employment contracts with fixed periods and the agreement must be voluntary and not designed to circumvent laws on security of tenure. Overseas Filipino workers or the OFWs. They are Filipinos engaged in remunerated activities in a country where they are not legal residents. They are governed by the Migrant Workers and Overseas Filipinos Act of 1995.20. Special workers include apprentice, learners, and handicapped workers. Apprentice. These are individuals covered by a written apprenticeship agreement with an employer or recognized entity. They undergo training for an approved apprenticeable occupation, which requires practical on-the-job training supplemented by theoretical instruction. The apprenticeship period lasts up to 6 months. Learners. Learners are trainees in semi-skilled and other industrial occupations that can be learned through practical on-the-job training in a short period not exceeding 3 months. They are employed with experienced workers are unavailable to prevent employment opportunities from being curtailed and when their employment doesn't create unfair competition or lower working standards. Handicapped workers. These individuals have impaired earning activities due to age, physical or mental deficiency, or injury. Under the Magna Carta for disabled persons suffer from restrictions or lack of different abilities resulting from impairment. Qualified disabled employees are entitled to the same terms and conditions of employment, compensation, privileges, benefits, and incentives as qualified able-bodied persons. Benefits, privileges, policies affecting employees. Minimum wage. Minimum wage rates are determined by regional, tripartite, and productivity boards under Republic Act No. 6727. It aims to promote productivity improvement and ensure a decent standard of living for workers and their families. Collective bargaining. Collective bargaining involves negotiating agreements on wages, working hours, etc. Through written contracts or collective bargaining agreements or CBA, it's a mutual obligation between employers and employees initiated by the latter. Mechanisms are set in motion based on certain conditions leading to potential strikes or lockouts. If negotiation fails, CBAs must be ratified by the majority of all workers in the bargaining unit and registered with the appropriate authorities. Labor Management Council. LMCs provide a platform for communication between management and employees, promoting industrial peace and dispute resolution. They are formed in both organization and unorganized establishments, serving as a forum for airing concerns and preventing or resolving disputes without formal collective bargaining. Employee representatives are elected democratically, ensuring impartiality. Maternity and paternity. Maternity leave is granted to eligible female employees for childbirth or miscarriage under RA 8282, while paternity leave is provided to married male employees for the birth of their legitimate spouse's child under RA 8187. Solo parents are entitled to additional leave under RA 8972. Conditions for availing these benefits are specified in their respective laws. Union right strikes. Labor organizations have the right to represent members for collective bargaining and sue on their behalf. Strikes and lockouts are temporary work stoppage due to labor disputes with grounds limited to collective bargaining, deadlock of unfair labor practices. Strike must follow specific procedures including notice filing, cooling off periods, and strike votes. Unfair labor practices disrupt industrial peace and violate workers' constitutional rights. Service charges. Service charges collected by certain establishments and distributed between employees and management according to law. Employment contracts. Employment contracts regulate the relationship between employers and employees with provision ensuring compliance with company rules, safety protocols, job description, and disciplinary actions. Contracts should be clear, voluntary, and in line with labor laws favoring the safety and decent living standards of employees. That benefits under the Social Security law and Employees Compensation Fund provide financial assistance to beneficiaries of deceased members including funeraria grants and pensions. Health benefits. Social Security law and PhilHealth provide sickness, medical, and hospitalization benefits to eligible members and their dependents. Additional benefits are available for work-related disabilities. Drug testing. Mandatory drug testing is required by law for officers and employees in workplaces to mitigate risk. Positive results can lead to administrative actions, including suspension or termination. Retirement. Retirement benefits are provided under the Labor Code and collective bargaining agreements, entitling employees to receive retirement pay upon reaching the compulsory retirement age for completion of service years. Uniform policies. Certain tourism establishments enforce uniform policies for employees, ensuring a professional appearance and adherence to grooming standards. SSS and PhilHealth. Employees are covered by SSS, PhilHealth Employees Compensation Commission and Pag-ibig, providing financial assistance and health benefits. Membership to these programs is mandatory for eligible employees, and benefits include housing loans, calamity assistance, medical coverage, and provident savings program. Laws against discrimination. The law. Article 3 Declaration of Basic Policy. The state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The law against discrimination with respect to labor are as follows. Republic Act No. 7277, also known as the Magna Carta for Disabled Persons. Republic Act 6725, strengthening the prohibition and discrimination against women with respect to terms and conditions of employment. Presidential Decree 966, July 20, 1976, declaring violations of the International Convention on the Elimination of All Forms of Racial Discrimination to be criminal offenses and providing penalties therefor. Employment for women. The Labor Code of the Philippines provides protection for the working women. Consequently, no woman, regardless of age, shall be employed or permitted to work in any commercial undertaking between midnight and 6 o'clock in the morning the following day, except in cases where the women employee has been engaged to provide health and welfare services or when the nature of the work requires the dignity of women. An employer is required to provide facilities such as seats, separate toilet rooms and lavatories, a dressing room, and a nursery in the workplace for their women employees. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tactility that upon getting married she shall be deemed resigned, separated, or discharged from employment by reason of her marriage. Best labor practices in tourism establishments. Sexual harassment in the workplace. In a work-related environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or the continued employment of said individual, or in granting said individual favorable compensation, terms, conditions, promotions, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee, which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. The above acts would impair the employee's right or privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. In this regard, it shall be the duty of the employer to prevent or deter the commission of the acts of sexual harassment and promulgate appropriate rules and regulations in consultation with and jointly approved by employees, prescribing the procedure for the investigation of sexual harassment cases and the administrative sanctions. That ends my report. Thank you.